Okay, well, good morning from me. Of course, good evening to yourselves, most of you being based in the Southern Hemisphere. My title for this webinar is slightly different to that advertised, but the content is exactly the same. I want to talk to you about the ongoing political crisis that we've got in the UK, Brexit, but in a specific way, because there's part of it that relates to the concept of animal sentience and animal welfare. I want to give full credit to my co-author for the paper that actually this is based on. That's Jessica Horton. She's not available at the moment. She's a PhD candidate at Northumbria University. But we did a study, which I'll talk about a little bit later, which coincided with the furor that came up around Parliament rejecting a particular version of animal sentience, and we thought it was a good opportunity to publish that work. You see on this slide here, we've got my contact details, much as they were for the last webinar that I did on cloning. And you can contact me, and I can, if you've got questions for Jessica or want to contact Jessica, I can pass those on. I've also got a blog which is a bit moribund at the moment, I'm afraid, because one or two things have prevented me from getting onto it, but it does at least allow those of you not in the legal field to access some of the material that I've been working on over the last 6 or 8 years, without it being too dense and too impenetrable to a non-specialist. So if you want to have a look at that, feel free. It's at the bottom of that screen there. So just to point out that there are some publications that you could follow up what we're doing here with if you wanted to look at the full detail. The first one is the article that this is based on, and the first two are not yet available, but they will be soon. The second two you could access now via my profile on the web, which is there in blue. Just click on publications and outputs. I've got a book as well. It's a bit pricey. It's not my decision, I assure you. So if you did want the same material, feel free to access my thesis, which is at the bottom of the screen there. Again, the same link, publications and outputs. Very, very similar material, and it won't cost you anything. So on to Brexit. Well, as you can see from the visual representation I've put there, most people would agree that it's a car crash so far. Even if you're an ardent Leaver or a pro-Remain person, which is more or less the camps that most of the UK falls into now, and it's getting quite vociferous in the level of debate, to say the least. You won't be happy with the way things are. It's an absolute mess. So let me just moving beyond that, just to see what we have achieved so far with this. The point of the webinar is to talk about one specific clause in the European Union Withdrawal Act that we have been working on in Parliament for the last two and a half years. Unprecedented levels of debate, hours spent, amendments passed and lost. And I'll talk a little bit about how that affects animal welfare very shortly. I realise that, as I say, most of my audience today is from Australia and New Zealand, so I just want to point out that it is relevant to yourselves as well, because once we have exited the European Union, we'll be free to make very different trade deals, immigration arrangements, and so on with the rest of the world. And New Zealand, Australia, India, Southern America, Africa, all those markets will become ones that we can deal with freely, also we're told. But from the point of view of those of you listening from it with an animal welfare interest, of course, there's two things about that. First of all, we haven't got enough doctors, nurses, or indeed vets, animal welfare practitioners of all sorts in this country, and if we're going to have the same difficulty getting them through the immigration process from the European Union, my own vets are mostly Eastern European for a start, then we're going to we're going to be reaching further afield, and it may well be that there are loosening of the immigration restrictions on professionals moving from India, Southeast Asia generally, Australasia, to fill the gaps which are definitely going to be there, in my opinion. And furthermore, if we're going to trade, then we do need some sort of parity in terms of animal welfare, slaughter rules, meat processing, and so on. We've already had quite a debate here about the way that meat is processed in the US, and if we're going to deal with the US, then there may well be a difference in the arrangements, and which may cause a problem. So these are things to be thrashed out once we've actually exited the EU, if we ever do, because that's still a possibility that we don't. And to bring it up to date, the Australian Capital Territory has recently been looking at a bill to enshrine animal sentience into law in that region, and that is very pertinent to this discussion. I'll talk a little bit more about that in a bit. So just to get us all up to speed as to where we are and how the little bit of animal welfare legislation actually fits into the general picture. The briefest of history is that we voted to leave by a relatively narrow margin in June 2016, and the mechanism for doing that is Article 50 of what's known as the Lisbon Treaty, or to give it its full title, the Treaty for the Functioning of the European Union, the TFEU. So we talk about triggering Article 50, which we did about 2 years ago, and we should have left in the end of March 2019. But because we had a deal, including the animal sentience bit, with the EU, we thought we were ready to go. But Parliament itself in the UK has voted down the deal 3 times now, causing the constitutional crisis that I mentioned. It's more than likely that we're going to have a change of leader, more than likely possibly we'll have a general election, possibly a referendum about whether we should continue with the leaving process. All these things are still there because of all this debate and uncertainty. But to give you an idea of the options, should we actually leave, what's known as a soft Brexit is where we leave the European Union, but we have many of the rules, including rules about animal welfare, still in place. That is not favoured by those who wish to leave with no ties at all. The option which could happen still is that we leave without any kind of treaty over trade, and we trade with the EU just like we would any other country, Mexico, Russia, Nigeria, any country that's nothing to do with the EU. So what's the central point for this webinar? Well, a key amendment in the Act that was debated to formalise leaving was an amendment around the definition of animal sentience. Within the Lisbon Treaty, which is the overarching legislation for the whole of the EU, including us as we speak, there is a section which overtly acknowledges animal sentience, and we don't at the moment have anything quite as overt as that in UK legislation. Now, you see it there on your screen, and the bit that matters really is in yellow. Since animals are sentient beings, member states should pay full regard to the welfare requirements of animals. What doesn't get so much press is the bit that comes after it, though, which is that in fact that isn't enough of a restriction to prevent, for example, religious slaughter, which is a very controversial subject, both halal slaughter for the Islamic faith and kosher slaughter for the Jewish faith as well. And that particular tension hasn't been resolved. But moving on from that for a moment, what we had almost immediately, which is was quite unique given the lack of time for any debate on anything other than Brexit itself over the last 2 years, it was quite unprecedented that all of a sudden, because of a media and social media furore and a backlash, the Environment Secretary went on TV and radio within days to say, just because we're ditching the EU definition of animal sentience, don't feel that the UK isn't going to protect animal welfare adequately. And he said the words, I heard him myself, he said, trust us in Parliament to protect animal welfare even after we've left the EU. Well, there was quite a storm, and there was little doubt that that was what produced what's now known as the Animal Welfare Sentencing and Recognition of Sentience draft bill, which turned up within a week or so of this social media backlash. Now, that went out for consultation for 2 months, which is nothing at all, really, bearing in mind the Christmas is in the middle of it. And the questions that were asked were on the bottom of this slide here. The questions were, inter alia, they were people asking people, should we define the term sentience, and should we explicitly define the welfare needs of animals? Now, the reason why that went out to consultation was, of course, because there's always a tension between animal welfare and the fact that we're a meat-eating nation. So clearly, it always amuses me slightly that we talk about the welfare of animals in farms right up until the point where we summarily execute them in order to eat them. There is something of a paradox there. So you've got the meat industry, you've got some sections of the sport industry where you've got tensions between animal welfare and what people require of animals. So that was the reason for the consultation. Now, we were in the process of doing a study anyway into the way that the UK protects animal sentience in welfare. But the question might be in your minds as to why focus on domesticated animals rather than animals generally. Well, very often in a study you have to try to limit the scope of what you're doing to a manageable size, and we could have looked at the farming, we could have looked at conservation, zoos, scientific experimentation, but we didn't feel we could do that with the resources that we had. And one of the things that particularly interested us was that this concept of nature deficit disorder, which Richard Louv first raised, and is also a feature of National Trust documentation here. Essentially, in developed countries, you find that people are increasingly 2 or more generations away from the land, and that produces a bit of a disconnect between the image or the description of an animal or a much loved picture in a children's book and the actual reality of the flesh of that animal on a tray on a supermarket shelf, or as I say, in a bucket of fried chicken. And that has a lot to do with social construction, and I'd done quite a bit of work on social construction of horses already in my work, and I felt that there was some themes to be drawn out of that. Stibb puts that cultural constructs determine the fate of animals. Just think, for example, that we don't talk about pig meat, we talk about pork. We don't talk about cow meat, we talk about beef, and so on. And that has a lot to do with the way that the creatures are socially constructed and the way we socially construct the produce of those animals. So why horses? Well, myself and my co-author are interested in horses. I ride. I've previously done a considerable amount of research into horses in sport and in culture. There is, in my view, an unparalleled relationship between Homo sapiens and Equus ferus cabalis, the domesticated horse, and it has an enduring nature way beyond what we might have thought of in the past as the powerhouse that horses were. Indeed, we waged war with them, we have ploughed fields and delivered milk and so on. This is all the past, but we still see huge influence from the equine species. In sport, social scientists like Gilbert, Latimer and Burke, they have discussed the way that horses at the elite level have even achieved the social construct of the athlete celebrity. And if you want a simple pictorial bit of evidence of that, Australian Vogue in 2012 had a picture of black caviar on it, and more recently there's been another sports horse on Vogue's front cover. They have their own Facebook pages when they're famous enough, and so on, and fan pages. Psychologists like Prupes and McComb have looked at the way that horses can recognise different faces based on cross-modal recognition, different senses at the same time. There's a lot of work going on in this area. And just on a daily level, we see horse imagery in our language, and in the culture around us, film, sculpture, art, wearing apparel, sport, of course, which gives us this somewhat unique position that this creature has in the animal kingdom, and it gives us the best candidate for a single species to focus on this legal concept of animal sentience. We do look at other animals in this study, but we always come back to the horse. So our starting point for animal sentience was the Cambridge Declaration on Consciousness, signed by a number of scientists in 2012, and it it acknowledged that plenty of other species other than humans possess the neurological substrates to have consciousness, to have feelings, to think more closely to the way that we do than perhaps historically we might have acknowledged. It is limited to mammals, birds, and many other creatures, not clearly at the moment through to more basic animals, if you might want to say, down to the single-celled animal, of course. It's more complex creatures that it's talking about. So with that in mind, how has UK animal welfare law developed? Well, you can see for yourselves a raft of legislation coming out predominantly in the 1800s, which more and more acknowledged the need to protect animals from cruelty. But the real sea change was in 1911, the Protection of Animals Act, which was the only act we had actually right through till 2006, nearly 100 years. And it marks the beginning of the contemporary legal attitude to animals. It certainly doesn't acknowledge sentience, but it does acknowledge the concept of being cruel in a way that that legislation hadn't done before. And of course, the interesting thing about that is, of course, you can't be cruel or wicked or evil or spiteful towards something that can't feel or perceive. So there was the beginnings of this idea that animals might be able to perceive in a way that humans can. And for the first time, prison and fines were included in this legislation. But the bit of legislation that effectively Michael Gove and others wanted us to trust them on the history of is the Animal Welfare Act 2006, which came into force in 2007, and its key benefit really is that it's proactive rather than reactive. The PAA of 1911 was about reacting to cruelty, whereas there's a certain amount of inspection and preventative measures that exist in the Animal Welfare Act. So that's what we really wanted to look at, to see whether we could indeed trust Mr. Gove and his colleagues to protect animal sentience with new law after our exit from the EU. But we found some problems. We found problems that weren't limited just to the Act itself. They were also with interpretation and resources, and this might chime with experiences you may have in your own jurisdictions around legislation. It's only as good as the way people put it into practice. One of the big problems is that the acknowledgement of animal sentience is in the marginal notes. It's not in the statute itself. So as we sit here today, we don't have animal sentience enshrined in our legislation. Not the case around the world, as we'll see. And further, when we looked at the sentences, the way the courts had actually interpreted this concept of animal sentience, we found that, generally speaking, without being open about it, the sanction that was placed on the human who had been cruel, for want of a better word, or neglectful, the sanction tended to reflect the type of animal we were talking about. So if it was a useful animal, horses, cattle and sheep, intrinsic value, you get more protection effectively than if it's not one of those categories. And that's reflected in the fact that if you're not talking about animal welfare law at all in the UK, you're talking about property law, which is the other way that animals are protected, then in fact the offence is criminal damage. So if you injure a dog but you aren't cruel to it, then you may in fact end up with a conviction for criminal damage. And that reflects the attitude of courts and the public towards animals as property going back decades and centuries. And a lot of this may have something to do with the fact that English law and Anglo-American legal systems generally, their law is actually derived from biblical ideas. Go back far enough, if you were a priest, you were a lawyer, basically. And if you think about Genesis and one or two of the Psalms in the Bible, you have a very strong sense that humans have dominion over animals and essentially can do what they like. It's very anthropocentric a view of the ecosystem, and it's certainly not something that I would accord with, but unfortunately many people still have that hangover from that past. And there was a survey done by a religious organization actually into the attitude of pastors and evangelical Christians towards animals in their sermons, and the answers were really quite worrying and startling. Animals don't have souls, my ministry is to people not animals, this sort of thing. So although we live in a relatively post-religious society, generally speaking, we can't ignore the influence of our religious-based history, particularly in the legal system. In terms of technical problems with the Act, well, Section 9 has a duty that you have to animals, but it doesn't say duty of care. In law, we have some pretty clear definitions of what duty of care is, whether you're talking about welfare of children laws, whether you're talking about negligence or personal injury laws, whether you're talking about criminal statutes to do with injury or death even. Pretty clear definitions of duty of care, but this concept of a duty, not strong, not as strong by any means, and we felt that that was a problem. The care that has to be given, that this duty mandates, is in the application of it in the courts is worrying as well, because it seems from the decisions that are made that it's not clear whether you judge the level of acceptable care to be objective or subjective. And what I mean by that is the care given that which a reasonable body of opinion would say is acceptable, or is it what that person thought was acceptable? Now, if it's to have a subjective element, then irrespective of the common freedoms that have been incorporated in the Act that we see there, then if you think about horses, there isn't necessarily an objective standard of care in a number of areas, because different disciplines have a different idea of what's acceptable. Race horses being broken at 2 and reining horses at 2. Barefoot trimming is controversial. The roll-cur method of training horses to bend their neck in dressage, different types of really quite severe bit, they're all different in the way that they're viewed by different disciplines. So where is that consistency if we're saying, well, it's up to what the person thought was acceptable? That doesn't seem to work. There's also a lack of a mandatory statutory authority in the Act to enforce it at all, so it's left to local authorities and the voluntary sector, the RSPCA. We've had a period of austerity since 2008, which has meant both of those areas, both of those sectors have been quite badly underfunded, particularly the public sector. So the amount of enforcement personnel and resources is not great at all. Once you get the thing to court, the case to court, you've got deprivations of ownership and future bans of ownership. They're available, but again, for the same reasons of the lack of a mandatory authority, you've got no clear framework for monitoring those bans, and we have no animal abusers registry, although one has been mooted. In terms of equine specific issues, a couple of slides back, I forgot to mention it. There were a couple of acts of parliament which regulate riding establishments, but don't be deceived by that. That is predominantly to ensure that the humans are safe being given riding lessons. There is virtually no legislation in this country, apart from planning regulations, that regulates the treatment of animals in livery or private boarding, if you like. And you compare that with the absolute raft of regulations and laws that apply to kennels and categories, it is quite remarkable that nothing has been put in place. We can't even properly have a census of the number of horses in the UK, or indeed Europe. I've got colleagues who've written about that. And if you can't enumerate the number of horses you've got, it makes it very difficult to actually enforce their safety. Very few inspectors, even in the voluntary sector, have experience with equine cases or indeed the resources, just simple things like somewhere to put an injured animal, a vet that can treat it quickly, indeed a transport. These things are just not easily available to the voluntary sector. So you've got problems with the way that the Act is put into place, and it stems from the way the Act is written, in fact. So we have some reason for optimism in that the furor against the government produced very quickly, presumably because they thought it would win votes, animal welfare, sentencing and recognition of sentience draft bill. We've now got to the stage where it's ready to be debated, but as with all laws, to what extent is the provisions as they stand now, to what extent are they going to survive parliamentary debate? Because you've got, in our case, you've got 600 or more MPs, all potentially, who could suggest amendments, and then that's before you go into the upper chamber. And there is a doubt as to whether it will get parliamentary time at all. We might be facing a general election, we might be facing a new leader who might be much more interested in other matters than allowing this to go through Parliament. Even if it makes it through as it's drafted, there is a problem in that judges already have the ability to interpret animal sentience into the Act we've got now. It's in the marginal notes. They have a mechanism to take it into account, but they just don't seem to do that. And that may have something to do with this societal social construction that we talked about, that is so prevalent in our industrial society. So there is a doubt as to whether they would continue to do that, even with its front and centre in the Act itself, because there is every possibility that judges will interpret acts the way they see fit. It's very difficult to control the way judges actually interpret law. That's one of supposedly the benefits of a democratic system. Do excuse me, I'm fighting a cold as we speak. So some other jurisdictions and what they're doing with sentience. Well, the New Zealand government has officially recognised animals as sentient in legislation. We have a slightly tangential point, but nevertheless we have Quanto's law in Canada. It's more about giving extra recognition to service animals, that is police horses, police dogs, animals in service in the armed forces and so on, if they're injured, so that people are punished accordingly. It follows a parallel path, however, to the recognition of animals as something more than just property there, which is why we've included it. We did think that as a part of our discussions in researching this, that one of the ways through this, but bearing in mind as a meat-eating culture, we probably wouldn't get our ideas about animal sentience and welfare to the point where it'd be legislated, but one of the compromises might be to enshrine in legislation a new category of animal, which is living property, so that it's protected in a far more holistic way than just as the property of a human. And as I say, really at the point of writing this webinar, the Australian Capital Territory is the first in Australia to introduce a bill recognising animals as sentient beings. It'll be interesting to see how that unfolds and how that actually makes it through your legislative process in that territory as well. Now there's a link there that you can look at the policy developments in your jurisdiction, wherever that may be. I'm a bit loath to click on it right now because I did so earlier and it stopped my presentation. So I'll leave that for you to do at some point, especially as time is pressing. So to conclude, Hemingway said the best way to find out if you can trust someone is to trust them. And there we have Michael Gove again. There he is with his face for radio. And we thought, actually, trust in politicians is pretty hard to come by, even more than usual, since the Brexit debacle. And we think the record is not encouraging enough for us to be able to do that. We don't think that the concept of animal sentience is safe in the hands of politicians, even though it is potentially in an act that may get through Parliament as it stands. As we list there in our conclusions, we think there are a number of problems that are yet, it's too early to say. And bottom line for this study, up to now, the UK hasn't protected animal sentience sufficiently, and it could have done a lot better, especially since that definition should have been incorporated in our law by our membership of the EU, notwithstanding that we're leaving. One of the chinks of light, though, is that you might characterize this debate as anthropocentrism versus biocentrism, which is the idea of the human being actually part of a complex ecosystem, and any part of that collapses, then the whole thing does. And it may be that is gaining traction with the climate change protests we've had in the UK, the Extinction Rebellion, as it was called, the furor over plastics in the sea. There's a lot of buy-in with that type of debate, actually, far more than used to be. It's not fringe green stuff anymore. It's actually front and centre. This is what we need to do. We've had serious debate in our different parliaments around the UK, because there are 4 of them, given the Scotland and Wales and so forth, about the need to amend transport policy to take account of the fact that we've got to have 0 emissions here by 2050, and the fact that politicians are actually thinking this is a vote winner, it does encourage me. And of course, the level of extinctions, as everybody worried. So it may be, just maybe, that this direction of travel is enough to help speed this bill through. So all is not lost, and we shall see how we get on. Anyway, thank you very much for listening. As ever, questions are welcome, and follow up via my contact details also welcome. And I shall hand you back now to Julie.